Good morning, I'm Don Burgess, and I'm glad you're here with this Facebook Live interview. And today we have Barrister Rod Attride Stirling from ASW Law Firm. Rod, congratulations on your victory last week, and welcome this morning.
Thank you, thank you. Thank you for inviting me to speak with you.
I guess going back to last week, on the morning of or the night before the Court of Appeals was going to announce its decision, what were some of the thoughts, what were your emotions and feelings heading into that day?
Well, I, to be honest, was too busy to become emotional about it at that time, because normally with judgments, counsel will send a draft copy of the judgment 3 days in advance for typographical correction. So we have it, and the judgment is embargoed, so we can't share it with the public at all. So we know what the decision is going into court. On this occasion, the Court of Appeal did not send an embargoed copy of the judgment in advance, so we didn't know. And so I had to prepare on two bases, one that we win and one that we lose, because different things would happen in each event. So I was working till midnight preparing submissions. For example, if we won, there would be an application for stay. I had to prepare for that. So I was too busy to be thinking about the emotional aspects of it. There was plenty of time for that afterwards.
You argued for out Bermuda, Mary Ellen Jackson, Dr. Gordon Campbell, a few other defendants as well, on the basis of freedom conscious based on the Bermuda Constitution. Can you explain to the Bermuda public what that is coming out of the Constitution?
Sure. So to be clear, we had three primary arguments. One was we argued that the revocation provisions of the Domestic Partnership Act, and only the revocation provisions, which are those sections that revoked same-sex marriage, we argued that those sections had a religious purpose. And under English law and under common law, any legislation which is passed for a religious purpose, or primarily for a religious purpose, is in and of itself unconstitutional. And so even without getting into the freedom of conscience issues and all the other side issues, if legislation has a religious purpose, it fails. There's no saving it. And so our first argument was that the revocation provisions clearly had a religious purpose. They were a replacement of the Furbert Bill, and Mr. Furbert himself said 100 times that this had a religious purpose. Minister Walton Brown, who was the minister who bought the DPA, said expressly in Parliament and elsewhere that these provisions were bought to replace the Furbert Bill. So the revocation provisions were part and parcel of the old Furbert Bill, and they unquestionably had a religious purpose. The Court of Appeal said it was immediately obvious that they had a religious purpose, that they could have no other secular purpose. You couldn't point to any secular purpose. And so the first argument, which was successful, was that the legislation had a religious purpose, and so it was struck down on that basis alone. The court didn't have to, but they went on to consider the effect of the legislation. And the effect of the legislation was that it violated the freedom of conscience rights of many, many people. And that's Section 8 of the Constitution. And in that respect, what we mean is that some people have a deeply held, conscientiously held belief in marriage as an institution. Some people have that belief based on religious grounds. Some people have that belief based on cultural grounds or philosophical grounds. But many people have that belief. And it's easy to imagine that a straight person or gay person who grows up in Bermuda or any other place which is sufficiently similar, in a place where we value marriage highly and we attach all sorts of rights to it, but we value it as an institution highly. It's easy to imagine that a gay person who grows up in that culture that values marriage wants to be able to be married and has a belief in marriage. And the courts found that that the belief in marriage as an institution, whether it was same-sex or opposite sex, was a belief that was sufficiently deeply held to rise to the level of being protected under the Constitution, which protects the freedom of beliefs.
So freedom of conscience doesn't mean like somebody can on their own have one specific belief. It has to be a wider set of held beliefs by the society.
Well, the Constitution, when it refers to the freedom of conscience and beliefs, it doesn't set out a list of what beliefs are covered and what are not, which is why this case was novel, because although there are many cases in the UK and Canada and other places where different rights have been protected or been accepted as being protected, for example, a belief in veganism, a belief in pacifism, a belief in trade unionism. Because remember, once upon a time, it was illegal to join a trade union, or an opposition to trade unionism. In some countries, in some industries, they have what's referred to as a closed shop. If you want to get a job in this industry, you must join the union. And there have been cases where people have said, look, I philosophically don't want to join, I don't believe in unions. And the courts have said that that is a respected belief. Other beliefs would be the right to beat your children, which is a strange one, isn't it? But the Bible says, there's a quote in the Bible that says, spare the rod,
Spoil the child.
Spoil the child. And there's a case, and there was a case in the UK about 2 years ago called Williamson that went all the way up to the House of Lords, where a group of parents and private schools who wanted to be able to have physical chastisement of children as part of their religious beliefs sued the government because the UK government brought new legislation, an amendment to the Education Act, which forbade schools from beating children. Parents at home could still beat the children, but the schools could no longer do so. So the parents sued because they wanted their children to be beat by the schools when the children misbehaved. These weren't cruel parents. They were parents who believed that this was the way to chastise your children and to educate your children and to teach your children. And so, and at trial and in the Court of Appeal, they lost. The court ruled that their belief was not protected. In the Supreme Court, led by Lady Hale, she ruled that the courts below were wrong, that the belief that they had was sufficiently serious and heartfelt and based on legitimate Christian writings, but that's not the real requirement. It was a deeply held belief, and that it was protected under they were arguing under Article 9 of the European Convention, which is similar to our Section 8, freedom of conscience.
Right.
And that it was a protected right. But then she went on to say, but that's not the end of it. Because in relation to every constitutional type right, there's always a check on that. You can't just say, well, I have a religious right or a constitutional right to believe X, and therefore X is it. The state can always say, well, in a democracy, it may be reasonable for some of our rights to be curtailed. And in Williamson, Lady Hale said that one had to take into account also the rights of children. And there was a ton of expert evidence put into that case by the government that showed that there were risks of serious violence to children. Children had been injured by teachers. And the right to protection from violence of children trumped the right of the parents to have teachers, third parties, beat the children. And so the rights of the children trumped the other rights. Yeah. But the starting point is that the court recognized that there was a recognized right to beat your children. And so there are many, many different types of deeply held rights that are protected. In the case of Steinfeld, that was decided by the House of Lords in England only about 2 months ago. In that case, that involved two opposite sex partners who wanted to have a civil union, so the opposite of what we have in Bermuda. They didn't want marriage because they had a philosophical objection to marriage because of the patriarchal origins of marriage. And the court recognized that their conscientious objection to marriage as an institution was a protected right, that it was sufficiently serious, deeply held. It wasn't a joke. It wasn't someone just trying something on. It was a deeply held opposition to marriage. In England, the civil union legislation only applied to opposite sex partners. And they said, well, we're being discriminated against because we're straight.
Right.
And this meant they lost that trial. They lost in the Court of Appeal. Lady Justice Arden, who was then in the Court of Appeal, wrote a strong dissenting judgment in support of them. And her judgment was vindicated by the Supreme Court, led by Lady Hale, that said that no, these people do have a legitimate, conscientiously held objection to marriage, which has to be respected, and the government's arguments around it were rejected, and so the Supreme Court ruled in their favor. So we convinced the court, both at the Supreme Court level in Bermuda and the Court of Appeal, that if someone can have a recognized philosophical objection to the institution of marriage, the opposite side of that coin is that someone else could have a strong philosophical belief in marriage.
Right.
And so it's easy to believe that someone can have a strong belief in marriage. I mean, do you have a strong belief in marriage? I mean,
yeah. So part of the thing is, like, since the decision, Walter Roman, the deputy premier, came out and made a statement saying that, you know, they'll make a decision on whether or not they want to go forward. But he also added, you know, the people elected the government to make laws and to make decisions based on what the will of the people is. And since then, there have been several other people who have been saying, you know, we've elected legislature to make laws, and we expect the courts basically to uphold whatever laws that the legislature makes. What's your opinion on that?
well, I've heard that from numerous people, and even from some politicians. And I didn't hear what you say Walter Roban said, so I can't comment on that. But I have heard stuff like that from other people. And what it shows is a fundamental misunderstanding of the way democracy works. And it's really quite sad that some members of our legislature have such a poor understanding of the way our legislative system works and what their job is and what their job isn't. Under our constitutional arrangement and the constitutional arrangement in every other English-speaking country in the world, excluding England, which is different because England doesn't have a written constitution. But if you look at the United States, Canada, New Zealand, Australia, South Africa, all of these countries have written constitutions, and all of them say fundamentally the same thing. And one of the fundamental parts of any constitution is that the legislature may not pass legislation which is inconsistent with the Constitution. The legislature may not pass an act which violates the Constitution. And in every one of these systems, it is the job of the courts, the Constitution says this, it is the job of the courts to review legislation, to see if it's unconstitutional, and if it is, to strike it down. That is a fundamental part of our democracy. And in the US, the courts did exactly the same thing in 2015 in the Obergefell case, when they ruled that all the restrictions that prevented same-sex marriage in the US were unconstitutional, and the US court ruled that same-sex marriage was lawful. In Canada, four provincial courts made the same ruling, which eventually led the Canadian government to say, look, we're losing this in every single province. We need to correct it at a federal level, country level. But it was all done through the courts originally. Same as here. And so, you know, some of our legislators just don't understand the way our democracy works. And this is a fundamental part of our democratic system.
So basically, like, the Constitution's the supreme law of the land.
Yes. That's
In simple terms.
That's exactly it. I wish I had said that. That's it's much better put.
Okay. This victory, I mean, you talked a little bit about its far-reaching implications. Can you explain a little bit to the public on how this might affect the rest of the world?
Well, in all of the countries that have same-sex marriage, many of them have made the change legislatively, but quite a few have done it through the courts. I mentioned the US, Canada. South Africa led the way. South Africa was the first country that introduced same-sex marriage via the courts in 2005 in a case called Furi. And 10 years later, the US followed the South African courts. And that's a little-known fact. But in all, so there were 29 countries that now have same-sex marriage. So, and that is essentially almost all of the West has same-sex marriage, and there are many countries that don't, but there are also many countries that have very poor respect for human rights. And Bermuda has never really put itself with that group of companies when it comes to human rights issues. And so many countries do not have sexual orientation discrimination laws. It's not just that they don't have same-sex marriage, they don't even have laws that protect gay people from discrimination. They have no sexual orientation laws. But almost all of those countries do have a freedom of conscience provision in their constitution. And so this case opens up a new avenue of approach for people in some of those countries, not all of them.
Right.
But countries, the members of the Commonwealth that follow the common law system will be impacted by this potentially. Some of them unquestionably will be impacted by it. For example, Cayman has a case coming up in February that will be tried before their Chief Justice Smelly, and they will be relying on this very case. I had a conversation with the lawyer who's handling the Cayman case, and they're going to be relying very heavily on this judgment. And so the impact of this case in other parts of the world, I think, will be significant.
How does that make you feel? I mean, you smiled a little bit when you thought about when you were saying.
It's nice to know that, or to believe that one is having sort of a positive sort of influence on change. And you know, we've worked very hard, and it's nice to see it pay off.
Now, although sort of Bermuda leading the way in this, I think on the weekend there was a country that had put to a non-binding vote to the public with, I think it might have been Taiwan or Thailand.
It was Taiwan, yeah.
Taiwan, okay. I knew it was a T. On same-sex marriage, and the voters there rejected that. You know.
Well, it's part of a process. Remember, we had a referendum in which the voters rejected it. That's never the end of it, because in the Bermuda referendum, so few people turned out to vote, half the electorate, that it was declared to be invalid. If you look, although a majority of those who voted against same-sex marriage, if you look at the percentage of the electorate that they represent, it was less than 1/3. So although the preserved marriage folks like to say that the majority of Bermudians voted against same-sex marriage, that's not true, it's a lie. Less than 1/3 of Bermudians voted against same-sex marriage. And what that means is that 2/3 either voted in favor or just didn't care one way or the other. I mean, I know a lot of folks, who would not get off their backsides to go and vote for gay people to have rights. But if you were to ask them, I mean, do you object to gay people having rights? They'd say, no, I just don't care enough to go and vote for it. So 2/3 of the population either voted in favor of same-sex marriage or didn't care enough to come out to vote either way. But in terms of the people who oppose same-sex marriage, they were less than 1/3 of the population. And that's an important thing to keep in mind.
Yeah. But I mean, you could lump those people that didn't vote in with people who voted
You can
against
lump
it.
them wherever you want to lump them, but what you cannot say is that they opposed same-sex marriage. You can't say that they supported it, but you can't say that they opposed it.
Yeah, because I mean, part of the thing is the way you're choosing to frame it would say 2/3 one way, but that's a statistical thing that could go either way depending on the people.
What we
don't know. We don't know.
All that we can say, we can't say that they supported it, and I don't say that they supported it. I don't. What I say is that they did not oppose it, and that's an important point.
There's a cost factor. Bermuda's the government's trying
And
to decide.
just to conclude the previous question. So in Taiwan, I mean, Taiwan was the first. Taiwan was the first country in Asia, I believe, to move in this direction, and we haven't seen the end of it because the legislature is pushing forward with it. It's a non-binding referendum.
Right.
The legislature is pushing forward with it because they feel that they're compelled to, because of their constitution. So they wanted to be seen to be consulting with the people, but at the end of the day, they still have to move forward. So this is part of the process. India, only in the last 3 or 4 months, passed new legislation abolishing the criminalization of homosexual acts. And so there is a huge movement worldwide, and it's all going in one direction. Bermuda was the only country that suddenly took a step backwards, but we've corrected that now.
As far as costs, where do you estimate government's costs are going to be provided? Because one of the things that you also prepared for that morning was to apply for costs for Out Bermuda for your services and Mr. Pettingill for.
At the Supreme Court trial, the court ordered that the government pay all of my client's costs and all of Mark Pettingill's client's costs. And they would have been quite considerable, and that was just a trial cost.
When you say considerable, what a ballpark figure?
Let me sort of come back to that. Then we had the Court of Appeal, and in the Court of Appeal, the cost would have been equally large because there were several new issues that came up in the appeal. And so, at the appeal level, the Court of Appeal ordered. At trial, however, the court stayed the judgment, and so the Crown didn't have to pay the cost right away. In the Court of Appeal, the costs will now have doubled, and in addition, the government has to pay their own, and the court has ordered the government to pay all of our costs, and the government will also have to pay their own costs. So they will have all their internal lawyers working on it, and they have, I think, 3 lawyers from the AG's chambers in court during this trial.
It looked like a whole squad on both sides of lawyers and clerks and what have you.
There were a lot of people.
Yeah.
And they also flew in a Queen's Counsel, Mr. James Guthrie, QC, who is one of the most expensive lawyers that money can buy, and also one of the best lawyers, is his reputation. He's said to have done more Privy Council cases than any man alive or woman. So he's one of the most experienced lawyers in this area of practice. And I've heard reports that the government spent $400,000 on his brief fee. I don't know if that's right, but that would probably be in the right market, in the right sort of area. So if we go to the Privy Council, they'll have to again pay his brief fee again, or if they decide they don't want him anymore and they want someone else, it's going to cost them a similar number. So if you and let's assume that we get a QC and the cost is similar, who knows? I mean, just the cost of the next step of going to the Privy Council will be well in excess of $1 million, and that's just one step of it. So if you look at the cost of the trial, the Court of Appeal, and the Privy Council, you're looking at a figure of well in excess of $3 million. Well in excess of $3 million that the government will have to pay.
So it's an amount of money.
It's a lot of money at a time when the buses are not working and we can't afford to get spare parts for them, when the schools need help, when charities are being set up to get supplies for school kids, because I mean Bermuda has a lot of needs right now, and spending millions of dollars on lawyers shouldn't be a priority.
You talked about the cost of going to Privy Council. What do you think the chances are that this will go to the next step?
Well, I had hoped that it would not go to the next step. I thought that when the government brought in Mr. Guthrie QC, they had made a decision that it was that they would spend everything on this, fight on this, and if they won, great. And if they didn't, they would turn around and say, well, look, we hired the best lawyer that money can buy. We lost in the Court of Appeal. We have no hope of winning in the Privy Council. We're going to stop spending money now. I had hoped that that was the case. So when I heard that Guthrie was coming in, I was actually quite excited, because I thought this would end it now. But I've heard rumors that you probably have heard also, that the government have made a decision to appeal to the Privy Council in any event, which would be sad. And if they were going to do that, I would implore them first to get an opinion in writing from Mr. Guthrie QC or someone of his ilk. And if they are told in writing that if you challenge this, you have a good prospect of success, not a guarantee, no one gives guarantees, but that you are likely to win, then fine, go ahead and appeal. I can't believe that they will get any lawyer who understands this area of the law who will say in writing that the government is most likely to win. They're not. They're going to lose.
You've mentioned Lady Hale a couple times earlier in this interview. Why is she significant? What role does she have with the Privy Council?
Well, Lady Hale is the president of the Supreme Court. She's the head of the Supreme Court, which the English Supreme Court, which used to be called the House of Lords. The Judicial Committee of the House of Lords has been renamed as the Supreme Court. And the Supreme Court judges sit in the Privy Council when they're hearing appeals from the colonies, or from the territories, as we're now called. Lady Hale was one of the leading human rights lawyers in the UK, and then she went to the bench and has been a leading voice on human rights issues her entire career. Many of the judgments that we relied on in our case here in Bermuda were judgments of Lady Hale. And so, whilst it's impossible to predict what any judge will do in any case, we can say that we can look at the approach that she and the other members of that court take. And Lady Justice Arden, who decided the Steinfeld case in the Court of Appeal that I mentioned, the civil union case, she's been promoted to the Supreme Court, so she'll now be sitting in the Privy Council. The Privy Council court is it's a powerful court, and probably more liberal than that court has been in the past. And the approach that they've taken to these types of cases, the rights of gay people who've been discriminated for so long, is consistent. And so we believe we have a pretty good idea of how the Privy Council will approach this case, which gives us cause to be confident.
For the public, how does the Privy Council work? You know, there's a great interest at this point in time. How does it work? How many people are on the Privy Council? How many people actually sit and judge a case?
So the number of people who sit will vary. I expect that we'll have a tribunal of 5 members. And the people who sit in the Privy Council are the same judges who sit in the English Supreme Court. They're wearing a different hat, but they are exactly the same judges. So they're the judges who are the final Court of Appeal for the United Kingdom. But when they hear decisions from the territories, those same judges now sit in a chamber called the Privy Council, and they decide these appeals judicially. So it'll be likely a bench of 5.
So it's the same 5, or it's a different rotating 5?
It can vary. It can vary, but one could go to the English Supreme Court website and get a list of all the judges. But I mean, the two that I'm certain will be sitting because of their great interest in this will be Lady Hale and Lady Arden.
So they get to pick and choose which ones they sit on?
Lady Hale will decide who sits.
Okay. So it's not, I guess
the President will decide who sits.
Because like most Bermudans are familiar with the U.S. Supreme Court, where they've got 9 set justices who, you know ahead of time basically where they come from. But in this case, it's 5 people picked by Lady Hale.
Well, they're not 5 people. They're 5 members of the bench.
Yes. Well, sorry, that's what I meant.
Yeah.
5 learned people of the law.
Yeah. Well, 5 judges of the Supreme Court.
Yes. But not the whole Supreme Court.
It's unlikely.
Unlikely. What's the most it ever sits on this Privy Council in a case?
I think 7, I think,
7.
but I'm not certain.
And the minimum amount is?
They could probably sit with 3, but I think normally it's 5. They almost always sit with 5. Almost always. I mean.
Okay. Okay. Well, I was here with Mr. Attride Stirling. You've heard some of his thoughts on the case and the possibilities for the future as well. And we've got a little bit of a lesson on the Privy Council this morning as well. I'm Don Burgess. We thank you for watching this Facebook Live video for Burn News, and I hope you have a beautiful day.
Thanks, Don.